Good afternoon, everybody. Keith here. Hoping everybody's having a good day, enjoying life, living life, loving life. Um, if you read the text of this video, you'll see I've got discussion going on here about proper names, and I'm hoping I can convey the thing about the fictitious name in regards to all these documents and court appearances and commercial transactions, secured transactions, whatever, and the use of the hyphen and clarification on different terms, titles, standards, stuff like that. And so today we're going to get to the Concise English Handbook. This is Hans P. Guth, 4th edition. And we're going to start out with the hyphen, because a lot of us are concerned about the correct grammatical way to place a proper name on an instrument, document, note, paper, whatever. The use of a proper name is something that's regarded as a singularity, in the best words that I can phrase it. And the way I'll explain this is that if we were to take 20 people and line them up side by side that all have the exact same name, and in this instance I'll use my name, Keith, my given name, which in respects to the hyphen as a connector would be Keith Orland. But when it comes to a proper name, we're talking about, again, like I said, in my opinion, it's based on a standard of singularity. Let's start out with what they say here in the Concise English Handbook about hyphen is the use of hyphen where required by current practice. It says the use of the hyphen is the least uniform and the least stable feature in the English spelling. In doubtful cases, the most recent edition of a reputable dictionary is the best available guide. And so when it comes to the hyphen, it's basically saying it's not required. It's just like a standard. And so it's a matter of usage in regards to the standards. And then the next one, in order to help convey this, it talks about compound words. And in compound words, we're talking about things that can be used together. You can say, that's a black bird, or you can say, that's a blackbird. Okay? So we have a black bird, two separate words, as a description of a thing that we see there. Or we can use the proper name of a singular bird type known as a blackbird. And neither one of them requires a hyphen. The connector for a singularity on blackbird is just a compound word, blackbird. Whereas in my given name, it's not a compound word, it's Keith Orland. And in order to connect them as the given name, you put a hyphen in there as a standard. It's not required, though. The distinction's going to come if you read the text, when we clearly show a separator. And in this case, in the English language, that separator is going to be a full stop colon. And again, if you read the text, you'll see the use of that. We're not going to get into the full stop colon here, except that I'm going to mention it. I'm not going to read anything out of here for it. In regards to the compound words such as great-grandfather or great-great-grandfather. Now we can have great grandfather because he does a great job. Or we can do great hyphen grandfather because he's a second generation grandfather, showing a singularity that is different than grandfather, being a great grandfather. The next one talks about tomorrow, today, nowadays, nevertheless, as singular words. And that's why I say the hyphen is talking about a singularity. We're going to single things out. Now the next one it talks about says prefixes. Prefixes, I like to use hyphens in prefixes because it helps me break the words down. That's generally the only reason I would use a hyphen for prefix context. And that I'm getting into more and more because of my studies of breaking down the words. It helps others to comprehend the breakdown of the words. And that's particularly the only reason I use them. Then it talks about group modifiers. And this is stuff that, again, I urge people to get yourself a Concise English Handbook and read this stuff for yourself so you can come to a better comprehension of it. Well, back to my lineup of 20 different people with the same singular given name of Keith. You line them all up and you say they're all Keith. Those are a bunch of Keiths. Keiths. Without an apostrophe. Okay? When we're talking about something that's possessive, the red shirt that the third guy from the end is wearing is Keith's shirt. That would be Keith apostrophe S. Simple distinction. Okay? When we're talking about the singularity and we've got 20 people lined up there, all named Keith, then we talk about that second part of the given name with the hyphen. Or without the hyphen, because again, it's just a standard, it's not a requirement. So the first guy's name is Keith, the second guy's name is Keith, the third guy's name is Keith. They're all named Keith. Well, how do we distinguish one from the other? When it comes to paperwork and the English language, we can discern the different Keiths either by Keith Little or Keith Smith or Keith Miller. But then when we get into that, there's so many people that have the same last name, which is actually a title. The last name is actually a title. It is the proper name of the origin and not of a singular thing. It's the title of an event, okay, or a location. The last name in reference to myself regarding Little comes from an area known as from an area where the river that ran through the valley was called the Little River. And so the people that settled in that valley went by Little, whether they were related or not. Some chose to spell it Little. Some chose to spell it Lytle. Various different spellings. But when we come to the distinction on paper again to discern two different Keith Littles, then we throw in that second given name. And again, we can either use a hyphen or not. And this is again where we go back to the distinction of the difference between the given name and the title using that full colon stop. Now, the full colon stop separates the proper name from the title. Period. Plain and simple. So when we're talking about things like United States, we have the United States upper and lowercase, which is the proper name of the government. And then we have United States all capitalized, which is the title of a corporation run by the government. We never see those with hyphens or anything, but those are both proper names according to the singular thing that it refers to. United States, upper and lowercase, is talking about what we think of as the territorial jurisdiction. The all caps United States is the corporate entity located in Washington, D.C. And when we talk about the proper names, we're thinking about like Democratic Party. And Democratic Party, both the D and the P would be capitalized, so it would be upper and lower case. But when we're talking about a group, as far as well, I'll say institutions, buildings, places, and we talk about Democratic Party institutions, then that wouldn't be necessarily capitalized. But when we're talking specifically about the Democratic Party itself, institutions of the Democratic Party, institutions wouldn't be capitalized. But then since it follows, it would be of the Democratic Party would be capitalized. If we're using Democratic Party institutions, we're referring to the institution in reference to a democratic whole. Okay? Not just a singularity. Same thing goes with like Orthodox. You could have Orthodox means, or you can have an Orthodox church. Orthodox means wouldn't be capitalized because it's just a description of many, whereas a Orthodox Church of Christ would be many Church of Christ. Orthodox would be capitalized because it's part of the proper name of that particular church. And so this is stuff I want people to think about when we're addressing these documents and everything, or they're being sent to us, or we're accepting them. We have to comprehend the context that they're being presented in. And that context specifically is in regards to the concise English or the style that they use. Everything that they're using here is not being addressed to us in the proper name. It's being addressed to us in what's known as a fictitious name. Period. Plain and simple. And here we're going to talk about Title 18 of the United States Code, which is your crimes section. And under Title 18 of the United States Code, Section 1341, it discusses frauds and swindles. I'm going to read this to you. It's a short section. Whoever, having devised or intending to devise any scheme or artifice to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises, or to sell, dispose of, loan, exchange, alter, give away, distribute, supply, or furnish, or procure for unlawful use any counterfeit or spurious coin, obligation, security, or other article, or anything represented to be, or intimated or held out to be, such counterfeit or spurious article for the purpose of executing such a scheme or artifice, or attempting to do so, places in any post office or authorized depository for mail matter, any matter or thing whatever to be sent or delivered by postal service, or deposits, or causes to be deposited, any matter or thing whatever to be sent or delivered by any private or commercial interstate carrier, or takes or receives therefrom any such matter or thing, or knowingly causes to be delivered by mail or such carrier, according to the direction thereon. According to the direction thereon. Again, we're talking about fictitious names, and they're trying to send it to a person, a fictitious person, but they're sending it to a live being, which is singularly very different than any and all fictitious persons. By mail, such carrier according to the direction thereon, or at the place at which it is directed to be delivered by the person to whom it is addressed, any such matter or thing shall be fined under this title or imprisoned not more than 20 years or both. Now the rest of it regards the Disaster Relief and Emergency Assistance Act on there. So I'm not going to get into that. But in regards to frauds and swindles, anytime they send you something in the mail that's not addressed to your proper name, they're addressing it to the person. And unless you're going to accept it in the capacity of officer, of executor of that person, or in other words, have the capacity of the office of executor, which you're the only one that can have that. Anybody else is a fiduciary. They have to be in an assigned position as a trustee or something. They cannot be executor. Only the live man of that proper name, who that person belongs to or is relative to, can hold that office, can have that capacity. Period. So unless you're willing to and capable of accepting that office of executor for that person, you can conditionally accept or reject or whatever. But unless that happens, you shouldn't be accepting this mail. You should be returning it regards to 18 U.S.C. 1341 and 1342 and 15 U.S.C. 1692, as well as making a note in there about 22 U.S. Code 254E, liability insurance for members of mission. Because, see, you're not related directly to the United States or any of these codes. You're foreign to them. And being foreign, you have your own mission. You have your own mission in life. What are you going to follow? Are you going to follow their mission? Or are you going to follow your own mission according to the word that you know? Is that word proper? Is it concise? Is it in their style? Is it in somebody else's style? These are all things we have to think about. And so I urge everybody to get yourself a concise English handbook and start learning the proper name and the distinction between that and any fictional name. And Title 22 Code, Title 22 of the U.S. Code, Section 254E, talks about liability insurance for members of a mission. And it says enforcement of liability insurance requirements. The Director of the Office of Foreign Missions. Office of Foreign Missions is the U.S. Department of State. They're under the it's a office under the U.S. Department of State, and that is the place I believe that we need to start contacting to ask questions about this stuff in regards to our foreign status. And that's all I'm going to mention about that. I don't want to get into that with you guys about this as far as the foreign stuff goes, but remember that Title 22 talks about foreign diplomatic and consular officers. So I suggest you do read that. But back to 18 U.S. Code. We did 1341. 18 U.S. Code 1342 is fictitious name or address. And this is another place where I want to make a distinction on address. If you're gonna use an address on a private site, get a private postal address and quit using the U.S. Postal Service. Use a parcel service, something like that. A lot of different places offer mailboxes that you can receive mail on a private side. The United States Postal Service is a contract venue. Okay? Think about that stuff. 1342. Again, another short section. Whoever, for the purpose of conducting, promoting, or carrying on by means of the Postal Service any scheme or device mentioned in section 1341 of this title, or any other unlawful business, uses or assumes or requests to be addressed by any fictitious, false, or assumed title, name, or address, or name other than his own proper name, or takes or receives from any post office or authorized depository of mail matter any letter, postal card, package, or other mail matter addressed to any such fictitious, false, or assumed title, name, or address, or name other than his own proper name, shall be fined under this title or imprisoned not more than 5 years or both. Plain and simple. Whoever, for the purpose of conducting, promoting, or carrying on by means of the Postal Service any scheme or device mentioned in section 1341 of this title, or any other unlawful business, uses or assumes or requests to be addressed by any fictitious, false, or assumed title, name, or address, or name other than his own proper name. Think about all these attorneys. They're not using their proper names. And they're accepting all kinds of stuff through the mail. And they're sending all kinds of stuff through the mail. Court clerks the same way. Whoever, for the purpose of conducting, promoting, or carrying on by means of the Postal Service any scheme or device. Court clerks are court clerks. They're seeking a money substance. Therefore, it is commercial. Uses or assumes a request to be addressed by any fictitious, false, or assumed title, name, or address, or name other than his own proper name. So when you get these envelopes that say Clerk of Court, all capital letters, couldn't possibly have been mailed by the Clerk of Courts, all capital letters. Clerk of Courts by all capital letters is a title. Uses or assumes or a request to be addressed by any fictitious, false, or assumed title. Plain and simple. And that is 1342. And that's a 5-year penalty. As we see in 1341, it was a 20-year penalty, along with fines and fees and penalties. We're going to click that one out. Click this one out. And then we're going to go to 15 U.S. Code 1692. It says, it's actually listed as subchapter 5, Debt Collection Practices. And Congressional Findings and Declaration of Purpose. A. Abusive practices. There is abundant evidence. This is a clear statement on public record, people. There is abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to the number of personal bankruptcies, to marital instability, to the loss of jobs, and to invasions of individual privacy. Now, this is a comment on public record. So they do recognize it, that it is a problem, and it is one of the things that is causing personal bankruptcies, marital instability, loss of jobs, and invasion to individual privacy. Inadequacy of laws. Existing laws and procedures for redressing these injuries are inadequate to protect consumers. In here, blue line highlighted consumer. Is the term consumer means an individual. An individual means a person. A person means a corporation. So, corporations, existing laws and procedure for addressing these injuries are inadequate to protect corporations. Really? Really? Seems like they're inadequate for redressing these inadequate for protecting the private individual privacy. And remember, individual privacy, even though individual means person, you still have an individual privacy to your own person. C, available non-abusive collection methods. Means other than misrepresentation. So in other words, correct. The record must be correct. Otherwise, it is a misrepresentation. Or other abusive debt collection practices are available for the effective collection of debts. Interstate commerce. Abusive debt collection practices are carried on to a substantial extent in interstate commerce and through means and instrumentalities of such commerce. Even where abusive debt collection practices are purely intrastate in character, they nevertheless directly affect interstate commerce. In other words, what that's saying here is it's preventing yourself from exiting a jurisdiction to perform your own commercial actions if you wish. Now, E, we finally talk about the purposes. It is the purpose of this subchapter to eliminate abusive debt collection practices by debt collectors to ensure that debt collectors who refrain from using abusive debt collection practices are not competitively disadvantaged, and to promote consistent state action to protect consumers against debt collection abuses. Not once does it ever talk about people. Okay? So this is where we go back to C, available non-abusive collection methods, means other than misrepresentation or other abusive debt collection practices are available for the effective collection of debts. So in other words, unless you stand up yourself in your private capacity and establish a correctness on the record, in, on, and for their record, recognizing yourself singularly separate from your person and the personal immunities or privileges and immunities that you qualify for through treaty, Vienna Convention, Treaty of Peace, privileges and immunities of protected persons. Think about this stuff, people. Who are they trying to protect? Persons. Whose persons are they trying to protect? That 14th Amendment. State and federal dual citizen. Yet they're using it against you. Who has the right of enforcement? The guy that's entitled to use that person. Again, if you're willing to accept the office of executor of that person. You can conditionally accept these things. And I suggest conditionally accepting them with the arbitration clause. Correcting the record with an arbitration clause to bring them back to the table if they'd like to discuss these matters any further, now that I placed the correction on the record, which they won't. And now that the correction has been placed on the record and they've acquiesced, you've completed a contract. You've established a valid contract by correcting the record, saying that their initiation of a contract to begin with is accepted. And now you have a performance that you're going to do. What's that performance? Office of Executor to correct the record. That Office of Executor comes with a fee. Nobody works for free. Set your fee and finalize that contract. How do you finalize a contract? Well, they've already acquiesced. Once they acquiesce once, you give them a notice of default. When they acquiesce, they've defaulted on honoring their initial offer. So now you send them a notice that they've defaulted. They acquiesce again. Now you send them a notice of default, an opportunity to cure. That's your third notice. That's exhaustion of administrative process. Now, if you exhaust that administrative process, and you've done so correctly through proper notices and everything, you can present that information to a private arbitrator who will look it over and let these people know that you've contacted a private arbitrator. Let them know who that private arbitrator is so that they have the opportunity to still cure it. But now the only cure is payment. And that arbitrator, whether they're present or not, should validate that contract unless they come to the table and prove that the information that I put forth is false, inaccurate. It's not that I put something out there for fraud, but because my intent is to correct the record. But if in my intent to correct the record, they do look over the paperwork and find an error, they can come back to the table and we can arbitrate it. We can discuss it. But as far as I know, everything they're doing, all this mailing stuff, and I'll post a picture specifically from a clerk of courts, and I didn't even use these. I used 31 U.S. Code 1321, subsection 73, where it clearly points out that the fiduciary assigned over decedents, estates of decedents and trust funds is the U.S. Department of State. And that's why I say Title 22, the Foreign Consular and Diplomatic Affairs, is directed at U.S. Department of State. They're the ones that do all this stuff and have all the information on the treaty and protections and immunities of persons. So we got to think about this stuff and realize that when we're accepting these mailings, we've got to know our capacities. We've got to know how to read. We've got to know how to comprehend what's being presented to us. Because if we don't comprehend what's being presented to us, then we can't possibly correct the record. So any correction of the record starts with yourself. You got to correct your own record. You got to correct what you've been taught. You've got to unlearn a lot of the things that you've learned and relearn this stuff so you can correct it. So think about this stuff, people, and remember, ask questions. Don't ever just take anything for granted anymore. Everything they do, I assure you, everything they do through the mail, and many times the U.S. Postal Service is complicit in it because they're not following their own regulations. I've had things that I sent back to the post office in regards to this that they turned around and tried to send back to me. Postman just took it and put it back in the mailbox. So what you do then is you turn around, you take it back to one of their blue boxes outside of the post office, or if you go inside the post office, you don't hand it to them directly. You put it inside the blue box, the blue drop box inside the post office, or find one on a street corner. So think about this stuff, people, and realize you do not have to put up with this. When we're talking about Title 15 of the United States Code, Section 1692, as far as the debt collections, let's look at definitions. Consumer. The term consumer means an individual. And again, like I said, individual means a person. And a person means a corporation. So a consumer is a corporation. I am not a consumer. I do not consume things. I use them. The term creditor means any person. Okay, the term creditor refers only to a person who both regularly extends, whether in connection with loans, sales of property or services, or otherwise consumer credit, which is payable by agreement in more than 4 installments, or for which the payment of a finance charge is or may be required, and is the person to whom the debt arising from the consumer credit transaction is initially payable on the face of the evidence of indebtedness. And means it includes also. In other words, the term creditor refers only to a person who both regularly extends and is the person to whom the debt arising from the consumer credit transaction is initially payable on the face of the evidence of the indebtedness. So again, when they're using that personal fictitious name without using the proper name, they're not talking about yourself at all. Period. Let's see if there's another one. This is a new one. Any person. As used in this subsection, the term any person includes any state, instrumentality of a state, or employee of a state, or an instrumentality of a state acting in his or her official capacity. Instrumentality of a state. What's an instrument? It's a debt instrument. It's a financial instrument. An instrumentality, a financial instrumentality of a state or employee of a state or instrumentality of a state acting. How can an instrumentality of a state act? It can't. In his or her official capacity. So the instrumentality is the person that somebody is performing as in the official capacity that they've been granted to act such way. So again, we're going back to the office of executor. That 14th Amendment dual citizen has been entitled to you, or has been bestowed upon you as an entitlement to use that person for commercial consumer transactions for the United States. It's an instrumentality, and you accepted the office of executor. So again, this is one of those places where I'm going to urge you to think about this stuff as an adult, competent to manage your own business affairs. You prove that competence by collapsing that trust and creating your own person so that you don't have to take an assignment of one of their offices or an entitlement of one of their offices by creating your own diplomatic and foreign office. And then you can use Title 22 in regards to protected persons. Debt collector. The term debt collector means any person, again, who uses any instrumentality. Instrumentality is an office. It's a debt office. Of interstate commerce or the mails in any business, the principal purpose of which is the collection of any debts, or who regularly collects or attempts to collect, directly or indirectly. Attorneys are not debt collectors, but they are collecting debts indirectly on behalf of somebody else and cannot do that. That's a no-no. They are not a debt collector. Directly or indirectly, debts owed or due or asserted to be owed or due another. Who are the debts owed to? Are they owed to the person or another? The debt can't possibly be owed to the person because the person can't own anything, including a debt. So they're portraying that there's a debt and you're accepting it without knowing. Mankind cannot be in debt. Our indebtedness was already forgiven through the birth, life, and crucifixion of Jesus. All our debts were forgiven. Period. Plain and simple. So we go forth in our proper name. He wasn't known as Jesus Christ. He wasn't known as Jesus Smith. He wasn't known as Jesus Miller. He wasn't known as Jesus Bachman. Known as Jesus. People don't know me as Keith Orland Little. They know me as Keith or L, a nickname. They know me by my proper name or my nickname. They don't know me by my person, Keith Orland Little. Some people do, but they don't call me Keith Orland Little. They call me Keith. A lot of you people on here call me L. That's fine. I don't mind that. I don't have a fictional person that they can bring into court named L. So think about this stuff, people. I urge you. We're going to go to 1692E, where we talk about the false and misleading representations. A debt collector may not use any false, deceptive, or misleading representation or means in connection with the collection of any debt. Without limiting the general application of the foregoing, the following conduct is a violation of this section. The false misrepresentation or implication that the debt collector is vouched for, bonded by, or affiliated with United States or any state, including the use of any badge, uniform, or facsimile thereof. So when this cop comes alongside the road, the nice policy enforcer pulls you up alongside the road, and he issues you a ticket, a traffic citation, traffic being synonymous with commerce, a commerce citation, he is citing a commercial statute. And saying already that you are a debt, and he is putting forth a collection of debt process. Again, just like a lawyer or an attorney, that's a no-no. He's issuing a debt without being indebted himself. He is doing it on behalf of another. The behalf that he's doing it on, the another on whose behalf that he's doing it for is a person. And he's saying you as the live man are indebted to the person without being qualified, vouched, bonded, or affiliated with the United States as a private entity. Because we know the United States is also a private entity. Okay. The false representation of the character, amount, or legal status of any debt or any services rendered or compensation which may be lawfully received by any debt collector for the collection of a debt. Okay? falls right in line with that person again. The false representation or implication that any individual is an attorney or that any communication is from an attorney. That's why they always put Esquire. The representation or implication that non-payment of any debt, get this people, in those traffic cases, the representation, child support cases, the alimony cases, any debt whatsoever, the representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person, or the seizure, garnishment, or attachment or sale of any property or wages of any person, unless such action is lawful and the debt collector or creditor intends to take such action. So again, the representation or implication that non-payment of any debt will result in the arrest or imprisonment of any person. Who is a person? Let me roll this sucker up, this birth certificate up. Here, put him in handcuffs. I don't know if you'd be able to hold him there. Might want to put him in a box or a drawer or something. He'll stay there. But if you walk around with him handcuffed to your handcuff, he's probably going to fall out. Arrest, to stop. The representation or implication that non-payment of any debt will result in the stop of any person. Will result in the stop of any person. Stop or imprisonment. Arrest or imprisonment. Stop and filing of any person. Stop and containment of any person. Well, don't I have to hand my person over in order for you to contain him? Think about this stuff, people. The threat to take any action that cannot legally be taken or that is not intended to be taken. The arrest of a live man is not intended to be taken. It's the arrest or imprisonment of any person. The threat to take any action that cannot legally be taken or that is not intended to be taken. Notice we're not talking lawfully, because they have absolutely no legal or lawful right to arrest a live man. You can arrest that person all you want. You can stop that person all you want. But you ain't supposed to be stopping me. The false representation or implication that a sale, referral, or other transfer of any interest in a debt shall cause the consumer to lose any claim or defense to payment of the debt. Shall cause the consumer. Remember, who's the consumer? The corporation, that attorney, that debt collector, whoever's trying to collect the debt from you, becomes subject to any practice prohibited by this subchapter. So let me read that again. The false representation or implication that a sale, referral, or other transfer of any interest. We're not talking about the actual physical thing, but the interest that I have myself in that debt. Keep it. Because I have no interest in debt. Suck on that one, guys. I have no interest in debt. I have my interest set in prosperity and abundance. And I will clarify that every chance I get. The only interest I would have in any debt would be if it were beneficial to myself and the rest of my brothers and sisters, so that we can gain prosperity and abundance. Got it? That's the only interest I have in any debt, is if it's beneficial to myself and yourselves. If it's only beneficial to myself, it may be detrimental to somebody else. I don't want to partake in that. Now, if it's detrimental to the system, the commercial system, it can be detrimental to a certain degree, and I'll be fine with that, because that's just a system. It's not another living being. Okay. The false representation or implication that the consumer committed any crime or other conduct in order to disgrace the consumer. Any conduct of affairs. So in other words, they committed any crime. They can't really commit a crime except in their private capacity by filling the office of the person and then acting in performance of the person, knowing that they were causing harm, or should have known they were causing harm. So it doesn't matter what capacity they're behaving in. Once they've been noticed that it's causing you harm, they're supposed to stop. That's supposed to be an immediate estoppel. Oh, I'm sorry, brother. I don't mean any detriment to you. I only mean to collect a debt from the person. See, they're supposed to know this stuff. If I know it, then why don't they? Communicating or threatening to communicate to any person credit information which is known or which should be known to be false, including the failure to communicate that a disputed debt is disputed. That's what I was just talking about. They should have known. Once you let them know that this is not my debt, this is a debt that belongs to the person of the office of executor, which is an office of the United States under the 14th Amendment as a dual citizenship to perform interstate commerce between and amongst the states and the federal government. I don't wish to operate that person. If I wish to perform commercially, I'll create my own person on an international level. And it will be my mission with my brothers and sisters to be fair and act in good faith as international law projects. The use or distribution of any written communication which simulates or is falsely represented to be a document authorized, issued, or approved by any court, official, or agency of the United States or any state, or which creates a false impression as to its source, authorization, or approval. The use or distribution of any written communication which simulates or is falsely represented to be a document authorized, issued, or approved by any court official or agency of the United States or any state, or which creates a false impression as to its source, authorization, or approval. So again, we're talking about a foreign entity here in person. Because that United States, this is all according to their person, their system, and how it operates interstate in interstate commerce. Number 10 is the important one. The use of any false representation or deceptive means to collect or attempt to collect any debt or to obtain information concerning a consumer. Remember, consumer is that person. And they're trying to obtain information concerning your person or the person which you have been entitled to use to collect a debt. And they've used the false representation or deceptive representation that you are the person. Can't do that. They use any false representation or deceptive means to collect or attempt to collect any debt by saying they are the debt collector. As a live man is a debt collector. A live man is not to collect a debt on another man. That's what I'm saying. Jesus gave his life for us, so that our sins may be forgiven, so that our debts are forgiven already. So when somebody acts in the performance of a person to collect a debt, and they've been given knowledge by another live being that they are a live being and they are collecting a debt against a man that owes no debt, we need to comprehend that. We need to clarify that the difference between ourselves and the person, the consumer. Number 11, the failure to disclose in the initial written communication with the consumer, and in addition, if the initial communication with the consumer is oral, in that initial oral communication, that the debt collector is attempting to collect a debt, and that any information obtained will be used for that purpose, and the failure to disclose in subsequent communication that the communication is from a debt collector, except that this paragraph shall not apply to a formal pleading made in connection with a legal action. Debt collection is a legal action. Except that this paragraph shall not apply to a formal pleading in connection with a legal action. Well, let's find out what a formal pleading is, huh? Either way, it's a misrepresentation. 12. The false representation or implication that accounts have been turned over to innocent purchasers for value. The false representation or implication that accounts have been turned over to innocent purchasers for value. So when somebody turns something over, they're turning it over to an innocent purchaser? Nah. These people that are buying these debts are buying these debts because they know it's a negotiable instrument, and they can negotiate with you, or they can negotiate it with somebody else because they've got something that they claim is a valid debt. Oh, somebody owes something? Let me invest in that debt. See how long they wait to pay that debt. The false representation or implication that documents are legal process. There's a good one. The false representation or implication that documents are legal process. That tells us right there that documents are not part of the legal process. They're just a representation. So what's the legal process? The legal process is the process that's due. And the process that's due is a correction of the records. Pure and simple. And the correction of the record starts with you, because they'll never correct it. Never. I assure you. The use of any business, company, or organization name other than the true name, notice it doesn't say proper name, it says true name of the debt collector's business, company, or organization. So when these attorneys send you these debt collection letters in the attorney's office name, and they're collecting a debt for a different company, the use of any business, company, or organization name other than the true name of the debt collector's business. So if you owe Sprint, aren't they supposed to collect the debt? If they can't collect the debt, they turn it over to a debt collector. They sell it to a debt collector saying, I can't collect. Now these debt collectors come out and they try to enforce it through these legal process with documents portraying that, well, we're going to have you thrown in jail, or we're going to bring you to court. You have to appear before a court. The fuck you do? Excuse me. My bad. My apologies, people. I've been working on that. So we'll go on to the next one. The false representation or implication that documents are not legal process forms or do not require action by the consumer. The false representation or implication that documents are not legal process forms or do not require action by the consumer. Think about that one, people. They do not require action by the consumer. They require action by you to, like I said, correct the record. Otherwise, they'll try to keep coming at you. And until you correct that record, they're going to keep enforcing it, imposing it. The false representation or implication that a debt collector operates or is employed by a consumer reporting agency as defined by Section 1681A F of this title. And there it is. That's your 15 U.S. Code 1692E. False or misleading representations. And every last one of them starts out with false and misleading representation. They're falsely misleading and representing that as a debt collector, you owe a debt, not your person, but you. Because the implication is that you'll be dragged into court, or that a credit report will be issued, interfering with your ability to perform interstate commerce by putting a bad mark on a credit report of your person. Really? And that's why we have to stand up and correct that record. It's very important. 1692G. Validation of debt. Notice of debt. Contents. Within 5 days after the initial communication with a consumer, in connection with the debt collection, or in connection with the collection of any debt, a debt collector shall, in other words, he must, unless the following information is contained in initial communication, or the consumer has paid the debt, send the consumer a written notice containing the amount of the debt, the name of the creditor to whom the debt is owed, a statement that unless the consumer, within 30 days after receipt of the notice, disputes the validity of the debt, or any portion thereof, the debt will be assumed to be valid by the debt collector. Assumed. Not judged, not proven, not true, not factual, but assumed to be valid by the debt collector. A statement that if the consumer notifies the debt collector in writing within 30-day period of the debt, or period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer, and a copy of such verification of judgment will be mailed to the consumer by the debt collector. So, judgment. Who's making the judgment? As far as I know, the debt collector. Or if they take it to court and they get some clown to sign off on it, that would be a judgment. But it would only be a judgment based on an assumption, as they clearly state. So even if after 30 days you fail, again, we go back to the other section, without any actions upon the consumer, which means if there's no action by the consumer, then means there doesn't necessarily have to be action by myself either. Okay? It's still just an assumption that somebody else passed a judgment on, that you still have an ability to correct the record on. So quit taking these threats and everything as valid. Let's see here. Back to where we were. That a judgment against the consumer and a copy of such verification of judgment will be mailed to the consumer by the debt collector, and a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor, if different from the current creditor. Okay? And they generally do this within that first initial notice. So these are the 5 points that we point out in our rejection letters. The amount of the debt. Well, the debt itself means an obligation. And since it's a financial instrument, the obligation belongs to the United States. See United States Code 18, Title 18, Section 8, Obligations and Other Securities of the United States. All instrumentalities used for commercial purposes are obligations of the United States because they've gotten rid of our way to exchange in lawful substance. Therefore, we have to use instrumentalities. The name of the creditor to whom the debt is owed, okay, they're going to tell you that the debt has been turned over to them. And when they say the debt has been turned over to them, they mean purchased. So we've got debt, creditor, consumer. A statement that unless the consumer, and the term consumer means an individual. When you look up the term individual, it means person. When you look up the term person, it means corporation. Okay, so again, a statement that unless the corporation, within 30 days after receipt of this notice, disputes the validity of the debt. Okay, so as a corporation, as executor of the office, if you're going to fill that office, you dispute, which you really can't do. Because what they're doing, like I said, is they're claiming a debt. And that's always going to be against the person, and that person is always going to be a fictional entity, either in contract with the United States, and therefore does owe a debt to the United States in exchange of paper, or as living men use them, the debt is an obligation of the United States and therefore not us, because we're using the instrumentality of a person. Number 4, a statement that if the consumer notifies the debt collector in writing within 30-day period that the debt or is disputed, the debt collector will obtain verification. This part here, we're not going to, again, just like 3, we're not going to dispute it in our rejection letters. We're going to point this stuff out. The name of the creditor to whom the debt is owed is not the same as the person that's sending me the mailing. So let's clarify that. The debt itself is not an obligation of myself as proper name Keith, the given name Keith, but a debt of that of a person that I have been entitled to hold an office of. I don't wish to hold the office of it. It's an obligation of the United States. Talk to them about it. A statement that if the consumer notifies the debt collector, number 4, again, the consumer is an obligation of the United States. Talk to them. Number 5, a statement that upon the consumer's written request within the 30-day period, the debt collector will provide the consumer with the name and address of the original creditor. The original creditor of all debts is the United States. They're the ones that gave you credit to use an office of a person that they created. And it's all based on credit. Moving of figures from one ledger to another. Not clearing of the ledger, but moving them from one ledger to another. The transferring of information. Whereas if you are truly a true creditor, you don't give them credit. You accept the credit that's already freely given in prosperity and abundance, and you use that to create more abundance so that people will give credit to your knowledge, to your experience, to the wisdom, and not some kind of commercial credit. They give you credit of your knowledge and experience by following in your way, in helping you perfect things, in helping you correct the record. And that's all this stuff is. So when I get done here shortly, I'm going to put up, along with this video, a picture of a letter or a envelope that was sent to a friend of mine from the clerk of courts. And again, referring not to 18 or Title 18 of the United States Code or 15 of the United States Code, but Title 31, Section 1321, subsection 73, wherein it clearly gives that fiduciary assignment to the United States, showing that the United States is obligated. And that's where it's uniform within the code. Title 13 or 31 of the United States Code, Section 1321, subsection 73, clarifies the same thing that's in Title 18 of the United States Code, Section 8, securities and other obligations of the United States. They're all decedent estates. They're all decedents because they're all persons. Every last one of them. A living estate is your living will. My word is my bond. Let my yea be my yea and my nay be my nay. Simple. So, before we get to that, before I end this video here, I've got the last little sections here to read off. Disputed debts. If the consumer notifies the debt collector in writing within 30-day period described in subsection A that the debt or any portion thereof is disputed, or that the consumer requests the name and address of the original creditor, the debt collector shall cease collection of the debt or any disputed portion thereof until the debt collector obtains verification of the debt or a copy of a judgment. Verification of the debt or a copy of a judgment, or the name and address of the original creditor and a copy of such verification or judgment, or name and address of the original creditor is mailed to the consumer by the debt collector. Collection activities and communications that do not otherwise violate this subchapter may continue during the 30-day period referred to in Section A, unless the consumer has notified the debt collector in writing that the debt or any portion of the debt is disputed, or that the consumer requests the name and address of the original creditor. Any collection activities and communication during the 30-day period may not overshadow or be inconsistent with the disclosure of the consumer's right to dispute the debt or request the name and address of the original creditor. So, when we verify Title 31 of the United States Code, Section 1321, subsection 73, being coinciding with Title 18 of the United States Code, Section 8, securities and other obligations of the United States, we verify that, we validate that, show them that. They're supposed to cease and desist. And these judges, like we discussed earlier, are supposed to know. They're supposed to know that they're judging based on assumptions. Okay, and this is the thing about arbitration that I've been talking about lately. When these guys go into court and they present their judge or their assumption of the debt to the judge, and the judge says, okay, well, I don't see any party here breaking the assumption, then the court presumes that the assumption is correct and passes a judgment. This is why it's important that we correct the record, and we do so in writing with certificates of mailing or registered mail, proof of service, third-party witnesses, proving that we have disputed that the information within this debt collection procedure which is not a legal procedure, is all done on presumption and assumption, and therefore we need to correct that assumption and presumption. And that's why we ask for validation or, quote, make a dispute. See, we're not actually supposed to do either of those. We're supposed to correct the record ourselves, because they're not going to. Admission of liability. This is your letter of liability. Okay? When we accept these offers to contract, this is what I was talking about earlier with the conditional acceptance. When we accept these offers with conditions, we should be placing at minimum 2 things on here, and that is a arbitration clause and notice of liability. Admission of liability. The failure of a consumer to dispute the validity of a debt under this section may not be construed by any court as admission of liability by the consumer. Okay? And again, this is uniform. This is the United States Code, and it's uniform with the Uniform Commercial Code in Section 3-402B, Subpart 1, where it says, the authorized representative giving an unambiguous authorized signature on the instrument is not liable for the person named in the instrument. And this is the kind of information we need to present to them in these rejection letters. And that's what I call them. I call them rejection letters, and I've done many of them. I've done one, there was one that was sent to a gal that they stated in it 3 times it was an offer. And so I pointed out to him clearly that this is an offer, and with unlimited powers of contract, I reserve the right to refuse the offer. So please accept our apologies, as we cannot accept your offer at this time. So their assumption is broken. Their assumption is broken. Period. Plain and simple. And we have record of it. How do we have record of it? We have 2 witnesses. It was her that was contacted, and it was myself that helped her construct the letter in return and mailed it myself. And though there's no certificate of service, I will at any time get on the stand and verify and testify that I did such thing. And the second witness will be her. So yeah, she needed help, and he did exactly as he said. Legal pleadings. Here we go. Formal pleadings. Remember we were just talking about that? Legal pleadings. A communication in the form of a formal pleading in a civil action shall not be treated as an initial communication for purposes of subsection A. Legal pleadings. A communication in the form of a formal pleading. So again, we're not going to ask them to validate the debt. We're not going to plead with them to validate the debt. We're not going to dispute the debt and ask them for proofs again, pleading with them. We're going to validate ourselves on and for the record that their assumption is incorrect. Notice provisions. The sending or delivery of any form or notice which does not relate to the collection of a debt and is expressly required by Title 26, Title 5 of Graham-Leach-Bliley Act, which is 15 U.S. Code Section 6801, or any provision of federal or state law relating to notice of data security breach or privacy, or any regulation prescribed under any such provision of law shall not be treated as an initial communication in connection with debt collection for the purposes of this section. So, anything that they send that does not relate to a collection of a debt shall not be treated as an initial communication. So what they're saying here is in their initial communication, they have to list these upper 5 parts. If they have any mind to attempt to collect a debt, they have to list these 5 parts in their initial communication, whether it be written or oral. Period. Plain and simple. And again, the amount of the debt, I don't care about the amount of the debt because I don't owe anything. I'm a live man. All debts are obligations of the United States. See Title 18 of the United States Code, Section 8. Consumer. Consumer is a corporation. See definition of person. It's a statement that unless the consumer within 30 days after receipt of the notice disputes the validity of the debt, I am not disputing the validity of the debt because the debt is an obligation of the United States and that is a valid debt to them. Or any portion thereof, the debt will be assumed to be valid by the debt collector. Okay, so statement 3, I'm going to clarify. The portion of the debt that they are wrong in is that they are addressing it to a person who I have been given entitlement to perform in the office of, if I wish to do so. If I wish to do so, then I accept conditionally as office of executor and put forth my notice of liability, arbitration clause, and a fee schedule. Number 4, a statement that if the consumer notifies the debt collector in writing within 30-day period of that period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt or a copy of a judgment against the consumer, and a copy of such verification or judgment will be mailed to the consumer. Now, what this is saying here, a statement that if a consumer notifies the debt collector in writing within the 30-day period that the debt or any portion thereof is disputed, the debt collector will obtain verification of the debt. So I've already verified the debt. Yeah, it's an obligation of the United States. You better check on that. The debt collector will obtain verification of the debt. I've given you notice. The debt belongs to the United States, not myself. You better verify that. Or a copy of a judgment. So if he goes to the court and doesn't present the information that I gave him notice of, that would be false and misleading representation to the judge because he has made an assumption by disregarding a notice that you gave him that you're not that person. That is indefinitely, or it is definitely fraud. Period. Now you have a tort claim. Now you can file a tort claim. 5, a statement that upon the consumer's written request within 30 days, the debt collector will provide the consumer with the name and address of the original creditor. Again, like I said, Title 18 of the United States Code, Section 8. The only one that could possibly be considered in debt is one that is crediting that debt. If you believe in this commercial construct of a financial system, then go ahead and be a creditor. Go ahead and take part as a secured party creditor and use that person. But make sure you know this stuff. Make sure you know how to act in regards to this stuff. Because when it comes to debt collection, like I mentioned, if you got a contract with Sprint and they can't collect from you, they go to a third party to collect a debt. That debt collector then assumes that the debt is valid, and he goes before a judge to get a judgment. Now he has a right to collect that debt. In the meantime, Sprint has already written it off. It's already been written off on their ledger. Somebody else has started a new ledger. All they did was transfer the information. That's fraud. Period. So I really urge you guys to think about this stuff and go back and look at my video. You can see it on YouTube as well as here on Facebook. I think I titled it Rejection Letters. And there's a lot of good information in regards to contract law, case law on contract law that the United States itself uses in regards to discerning the various different elements of putting forth valid contracts. And that's what these debt collectors are trying to do. They're trying to put forth a contract to collect a debt. And if they can't get the contract, then they turn around and present it to a judge on an assumption. And by presenting assumptions that they have, and then the judge will presume that those assumptions are valid because you have nobody stating any other corrections. So again, we have to either conditionally accept or be prepared that if it goes to court, we can come in with our two witnesses, whether it be registered mail that we've noticed them, and this is what we noticed them through, and we verified that the debt is an obligation of the United States. The person was created by the United States. I was given entitlement to use it. I do not wish to use it, or I wish to use it, whatever. There's so many different options, but we have to first comprehend what this stuff is, what the misrepresentation is. And so we go back to the proper name. Is it proper to be named this way on this paper? And it's not. They will never put your proper name on a piece of paper because they can't. They cannot do it. Period. Plain and simple. And that's again why I don't think I'll ever try to take anybody to court, because I don't want to act in that personal capacity. Live and let live. Forgive and be forgiven. If somebody commits a wrong with me, I'll live with it. I'll suffer it. I've suffered many days in jail. And if I believe I've got the right to be compensated, then I've got to comprehend the personal capacity and be able to log all the time and go through all these processes in order to get a judgment that isn't based on assumptions. Well, the courts care because you can name them as a party, Ken, to the fraud. When these collectors, these debt collectors, go to court and try to collect a debt, I'll tell you from personal experience with this gal that I'm talking about in regards to the envelope I'm going to post a picture of. She went to court on a debt collection, and when we got to court, the mediator or administrator or whoever you want to call him said that first we would be going to an outer room to discuss the matters with an attorney who then represented the debt collection. I don't know that attorneys are supposed to be purchasing these debts and then presenting assumptions. They're presenting themselves as an attorney, then they should be acting as an attorney. And that is misrepresentation right there by saying that they're an attorney and not clarifying that they are, in fact, collecting a debt as a debt collector, and they're not even known as a debt collector. Something's wrong there. So the first thing we did when we went into this outer room to meet with this gal, and her first concern was, well, who are you? You're not party to this. Excuse me? I'm her companion. They can't dispute that if we've got two witnesses saying that, yeah, he's my companion. So that's a hard word. That's a hard word for them to dispute. Companion. Think about that one, people. But anyway, when she said, okay, well, what's your concern? And I said, well, I need to validate this debt. Well, we can't have. Well, if you're going to dispute this, then we're going to have to go talk to the judge. Why? Because they're not going to be willing to accept corrections. So when you go in front of the judge and then you present the corrections, you're still only presenting the corrections to a judge who's basing the whole claim on an ex parte of the attorney that brought the case without my regard or her regard, but only regard to the person. So it's still being processed as ex parte, because that judge still doesn't want to listen to me or her. He's going to go based on the information that the attorney presents, unless we place information in, on, and for the record to correct the assumptions so that the judge can't presume. Plain and simple. So think about this stuff, people. And like I said, I'll post that picture. We've been discussing today proper names, Title 18 of the United States Code, 1341 and 1342 specifically, and Title 15 of the United States Code, which is, or Section 1692. Title 18 of the United States Code is your criminal code. Title 15 is a commerce code. And they both interplay, and you use them with each other. Period. Plain and simple. Hope you guys comprehend this. I'm sorry I made this video so long. I really wanted to be short and simple with the proper names, but I felt it pertinent to go into this other stuff so that we can learn how to clarify this proper name stuff on and for the record through rejection letters and proper jurisdictional transfers, proper record keeping. We want to ensure that they are noticed, so we use insured mail. That's your registered mail, your red label receipts. Or you can use third-party process servers, whether it be in person or by mailing. You know, you can use a third person that uses registered mail and have it double-backed or whatever. But think about this stuff, people, and really learn to start, or really start learning to educate yourself in proper names. Who is what, and what exactly are they referring to? Correct. If they purchase the debt, then the debt is discharged because it's been transferred from their ledger as a loss to another ledger as a gain. Okay, and that's what we're talking about in all commercial systems is profits and or gains and losses. This company lost, Sprint lost some money. They lost their commercial interest in the future of this contract because the other party no longer wishes to contract, and they really think they should. Well, I'm sorry, I don't wish to contract any longer. I feel your rates are outrageous. I've tried to contact you and litigate this problem and get the bill changed, and you still assess me the same bill and say, even though I've gone through many channels and even talked to your fraud department, then you turn around and send me an envelope saying you want your property back. When in fact, the property was given to us under that contract, and under contract negotiations, you turn around and acted against those negotiations and asserted that the original contract was still valid. Sorry, that null and voids the contract. Get lost, sucker. Plain and simple. Prove that the debt that you claim even belongs to myself, even if I have that particular property. You can't. The debt belongs to a person's and persons only. Period. And remember, people, if it wasn't for you guys, I wouldn't be doing this. I love y'all. God bless, and have a great day. Bye-bye.